24/7.
365 until I reach the heavens. I'm on a mission. I'm on a mission. I'm on a mission. Hustlers on a mission every day. Home Meat TV. We in a lit house, whatever you do, make sure you keep the light within you shining bright. You feel me? Yeah, man. So I gotta get me a new sponsor because they done fucked around and can't fix my website. So we still gonna do a capital and create a positive impact today and later. Fuck them haters. Get your paper straight like that. And never forget, real niggas do what they want to do. Bitch niggas do what they can. Hoe ass niggas gonna talk about it. And fuck niggas gonna hate regardless. I promise you that. So do your shit to the fullest, nigga. And today on Allegedly News, YNW Melly is back in court for a bond hearing as of Tuesday. So we're going to take a look at that and see what's going on with YNW Melly. Free Melly. And we're going to the story here. On Allegedly News.
Because she was noticed in the state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents she was relying upon. We don't know what materials she was given to review. Because we have no reports nor any of the substance of her testimony. When was she listed as a witness?
She was listed, I believe, Friday evening after he had hired her. She wants to be independent.
We're going to check something outside first.
The defense really offering a number of concessions if, in fact, Melly were allowed to await his retrial at home. They even went so far as to say that his record label, who he's apparently still under contract with, that they would be the ones to post his bond if he were granted one. Melly's real name is Jamel Demons. He is charged with the murders of two friends back in October of 2018. His attorneys told the judge today that if he were offered a bond, he would go on house arrest, living with family, that he would wear an ankle monitor so that law enforcement could track him, and that he would even have 3 security guards on him 24/7 to protect him. Prosecutors argued that the capital murder allegations against him, along with the pending tampering with a witness case, should prevent the defense really offering a number of concessions if, in fact, Melly were allowed to await his retrial at home. They even went so far as to say that his record label, who he's apparently still under contract with, that they would be the ones to post his bond if he were granted one. Melly's real name is Jamel Demons. He is charged with the murders of two friends back in October of 2018. His attorneys told the judge today that if he were offered a bond, he would go on house arrest, living with family, that he would wear an ankle monitor so that law enforcement could track him, and that he would even have 3 security guards on him 24/7 to protect him. Prosecutors argued that the capital murder allegations against him, along with the pending tampering with a witness case, should prevent him from receiving a bond. We spoke with Demons' mother outside of the courtroom about the hearing.
You know, he's been through a lot these last 6 years in the jail, 3 years with no phone calls, no visitation. You know, only time I do see him is when we're sitting in this courtroom and we're not even allowed to conversate with each other.
Man, that shit crazy. 3 years with no phone calls and no visitation. What the fuck y'all got going on, man? What the fuck he did that he couldn't have contact with his people for 3 years? No visits and no phone call. What the fuck for 3 years? And y'all ain't even motherfucking. He ain't even proven is guilty. The fuck kind of shit is that, man? Innocent until proven guilty. Ain't that what it's supposed to be? It's supposed to be innocent until proven guilty. But 3 years, no visits, no phone calls is some bullshit.
The defense really offering a number of concessions if, in
in
fact, Melly
bitch?
were allowed to await his retrial at home. They even went so far as
The fuck did he do in that bitch? All right, anyway. Feel like my shit crooked.
Yes, sir. I read your supplement.
Headphones be fucking up my shit, man.
That exclusionary rule will apply to the portions of the previous trial that subsequently Judge Murphy has found with evidence introduced in that trial that was obtained in violation of the Constitution. So your position is that the exclusionary rule applies in a pre-trial release of a bond.
I wouldn't call it an exclusionary rule.
Well, that's what you're asking.
I'm saying it should not be considered by the court, because the court, the law of this case is, it was suppressed, and it cannot be used by the state in any way.
Because I noticed
Including a bond.
you didn't cite any authority for that position.
It's
It's not
not
read
the
your
authority
argument.
that says that it isn't.
Well, I agree. It's an unusual procedural posture that someone's ruled on a motion to suppress before they rule on a bond.
I'm prepared to argue that, Judge.
That's his bro.
The case law is, it's a nullity. It doesn't exist anymore. And I believe, for all intents and purposes in this case, it cannot be considered. Bond is one of them.
That camera picked up on everything, didn't it?
Procedure that there has to be a certain order, or a order of motions. It doesn't say anything like that. But what it does say is, when a court makes a ruling and suppresses evidence, it no longer exists for the purposes of the case. And there's no law that says, except for bond hearing. No, it just isn't legally obtained nor available for the state to argue it. Maybe someday the appellate court may change that. But as we sit here today, from the date Judge Murphy ruled, and during all this time it's been up on appeal, it is the law of the case.
So let me ask you this, and then ask the state what their position is on that. But let's say I agree with you. Judge Murphy's order in the state of December 21st, 2023, the last paragraph of his order says, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this order. So I'm gonna take a wild guess that you all haven't gotten together yet and decided what is and what is not covered by this suppression order. I'd be correct about that?
So, not together, we have nothing. But it's all been argued before the court and very fully agreed.
So I'm just talking about right now, like, this is what I wanna know. I read the trial transcript, but I'm fully capable, no different than a Frank's here, of disregarding anything that I'm supposed to disregard. So what I need to know is what part am I supposed to disregard? Because Judge Murphy put in his order, you all were gonna come up with that. So what part would you like me to disregard?
Judge, we are honored with citizens, we're not doing evidentiary presentations on either side, that we take a 10-minute break and see if we can come up with a stipulation, but then, or at least list what we believe is loose.
Let me pause on that real quick. State, what's your position, first of all, on the argument that the exclusionary rule applies to a bond?
It's actually, I believe, addressed under 924.071, additional grounds for appeal by the state and time for taking state of cause. The last sentence, referring specifically to bond issues, talks about that. The defendant in custody whose case is stayed either automatically or by order of the court shall be released on his or her recognizance pending the appeal if he or she is charged with a bailable offense. Mr. Demons is not charged with a bailable offense. So what the court, or what the statute contemplates by that is if the state is some reason taking an appeal, which we did in this case, that his bond condition effectively remains the same, he's not entitled to the ROR. So I interpret that as because the issue is up on appeal, because the issue is essentially non-final, because it is before the fourth DCA now, that the exclusionary rule does not apply until there's an actual ruling from the fourth DCA, because obviously at that point there would be a definite change in posture depending upon what is ultimately suppressed or if anything is reversed by the court.
Right, so it's fine.
Well, hold on. You disagree with
Man, let that man go home, man. That man have been enough for 6 motherfucking years.
If I think that he is right, I'll ask you.
4 years before he even got to go to trial.
You two were all of you were supposed to get together and determine what specific evidence.
3 years with no contact,
and what
no
wasn't.
phone calls, no visits.
That never happened.
That has never happened.
That man finna go to trial in a couple months. Y'all can let that man out for 4 months, bitch. When the trial supposed to be October, man, y'all tripping. Let that man out. Trial in October.
A lot of evidence was recovered both from all the different ones.
They held the man for 3 years, no contact, no visits, no calls. They tripping by letting the man out for 3 months
I don't understand.
till the trial.
Speaking out of turn, yelling at someone that that's not true. What part of the rules of criminal procedure or the Florida statutes or any case law says?
I ain't even supposed to be eating this damn shit right now.
Is Judge Murphy liable?
I ain't even supposed to be eating this shit right now, man. They done goddamn.
Do you understand what I'm saying?
They got me over here goddamn stress eating, man. I ain't even supposed to be eating that here.
Everyone is entitled to respect. Everyone is entitled to be heard. One voice at a time for the court reporter. I'm not going to let anyone shout over you or interrupt you or call you a liar while you're sitting at the podium. And I can promise you, I'm not going to allow you to ever do it again. Do you have any questions about it? Okay. Go ahead, sir.
Judge, there was a lot of evidence that ultimately was suppressed. Not all of it was used in the first trial. Obviously, the team now is considering using stuff that is currently subject to suppression that we may end up using in the next trial, assuming the fourth reverses or whatever may come of it. In anticipation of today's hearing, in light of Mr. Benjamin's response or motion, I have a general idea of what's going to be excluded based upon the date ranges that are provided in the order, but I'm not in a position to give specifics, and it would probably take more than 10 minutes to actually go through it. If we were to itemize everything, that's going to be a rather lengthy endeavor. Probably at least a good day or two if we were to sit down and go through everything. And that's obviously we disagree that the exclusionary rule would apply.
No, I understand. This is, I believe that Judge Murphy's sentence at the end that Your Honor just read is about preparing for the next trial and deciding which evidence that was in the first trial is not suppressed, is not going to be, is pursuant to the motion to suppress. I don't believe it is needed to go over for purposes of Your Honor's consideration because it articulates exactly.
My boy look like he is not.
Parameters of the evidence that was suppressed. I don't think it says Exhibit A, Exhibit B in that manner, but it does have the parameters of what was suppressed by date and description. So
My boy ready to get the fuck up out of there.
I don't believe changes.
My boy said, man, y'all let him up out of this bitch. He is not coming back. He is gone.
Later consideration at the trial by exhibit number or exhibit letter, whichever they were on. So I think that's the difference.
I know that's what the fuck I be thinking, man. I'm up out of here. Y'all let me go. I'm gone.
It's available because
Y'all done twirled a nigga like this for 6 years. Y'all done twirled a nigga 3 years, no contact. Ain't even get a nigga a trial.
It shall be released in those other cases. It doesn't say, and he can't be considered in further bond motions. There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
Great.
I gave you a whole day. I'm happy to listen to anything you want to tell me. But this single sentence, I don't know that I agree with your interpretation. The court has not been moved to consider the suppression of specific evidence. So do you all want to tell me what you want me to not consider, or do you just want me to take a shot at it myself? I didn't have the benefit of sitting through this motion. So I don't have an order that says a motion to suppress is granted regarding the defendant's statement. A motion to suppress is granted regarding the cell phone records from T-Mobile. A motion to suppress is granted regarding any of these things. So I don't know what the specifics are, but I can figure it out. If you're telling me to take a shot, I guess I'll take a shot.
It is attached to the amended.
My boy like, say something, man. Goddamn, do something. Get me about this bitch.
Order of Judge Murphy.
Yeah, I read it.
Yeah.
That's why why I'm asking you this.
So if I could.
I mean, there's several that say he granted in part, denied in part.
May I clarify, Judge?
Sure.
So if you actually go into the order, a lot of it, he's a granted in part, denied in part. He goes and talks about the temporal span of those orders, saying specifically, highlighted what he said. In reference to his iPad account, that they're limited to a span.
A lot of people don't remember,
24
but his
hours
lawyer got into
from
some
the
bullshit,
sentence.
right?
He did not need to search his iPad account.
And her
for
motherfucking
evidence and location and communication.
father of her
But
kids had to call the police on her ass.
a specific time period.
She actually got booked on that bullshit. She actually got booked on that bullshit.
So the YNW booking Gmail.
She was trying to manipulate the situation or something. If I'm not mistaken, she was trying to manipulate that shit,
Time period. So anything that
saying some shit went a certain way, which it didn't.
could not come in.
They found out her ass was lying. They locked her ass up.
Could not come in. You were stuck to that time period. The next one would have been Twitter. Twitter was based on the same analogy that it was, the time period was too large and it had to be based upon data.
You can tell this ain't the other white man part of his job. He there to argue the case itself. Mother motherfucker do that bond hearing shit, request all that shit. That, but the actual case, that's why he just sitting there like that. He like, it ain't my time to shine yet, bitch.
The Snapchat was out from the time period creating the deaths and then time period after arrest.
Just home. Something unrelated.
I just need to know when the child will be available for a change play. Because when he keeps leaving, they can't call up for a custody.
We were supposed for 8:30, Judge, in custody, not.
My boy trying to understand everything that's going on in that bit right now. He like, man, y'all let me the fuck up out this bit.
Yes, sir. Go ahead, sir. Sorry.
Facebook, same thing, granted in part, denied in part. The temporal limitations was basis of the denied act. So basically saying from October 26th to February 19th, all of Facebook can come in, all of Snapchat, all his text messages can come in. So it was really clear that it was just everything was out from before the deaths and after the arrest. So that's when you're looking at granted in part, denied in part. It's granted as to the probable cause of the warrant, but it's denied as to the span of the warrant. So really what Judge Murphy did was break it down to where we had a time span of what was relevant and what could come in. His basis, quoting to basically the cell phone contains your entire life. There was no reason a lot of these warrants, and even the new warrants that the state has applied for, because they applied for new warrants based on the evidence that was suppressed, they're going back to the creation of the account. Murphy was very clear that he can't go back to the creation of the account. You have to sit within this time period, and that's what it said.
So for example, the cell phone mapping information that was testified to on the day of the homicide, October 26th, that was not suppressed.
If CDRs are all the way in, the cell
Yeah, yeah.
data, yes.
You agree with that?
I agree, Judge. If I can give the court a summary, this is my interpretation as to what's been suppressed and what can be considered if the court is going with exclusionary rule. As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As to the second warrant, the Twitter account that was granted in part, the past events from leading up to the homicide, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. As to as to number 3, the iCloud, that was granted in part. I think we noted that there was nothing of import there, so we weren't using anything from that, or we didn't recover anything from that. To the Snapchat, That was granted in part, again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Ryan Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial.
That's what you say, out? I don't understand, I just want to make sure.
Out. Ryan Hamilton's text, when you say out, as in they're not in evidence, they're suppressed. It's subject to suppression. It's subject to suppression.
I want to make sure out then it was suppressed.
As to number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for January, that remains in. So what the state lost there potentially are photographs related to gang-related activity, the defendant's membership in gangs, as well as some comments and communications about the defendant promoting the promotional video, which is also subject to the appeal because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th, or at least some of them were, I think. The Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity. Number 8, the T-Mobile records, the real-time location information, that was denied. Number 9, the T-Mobile records for historic location information as to the defendant, that was denied. Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 15th. So we obviously have to communicate with his phone.
Yes, we did. I just was saying that.
Some notes, some text messages.
Why would you do that?
What we also was suppressed were some of the notes and text messages from the past relating to gang activity.
Just do that. Yes, we did. I just was.
Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And at number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that. I believe it's more gang-related stuff. So effectively, what was suppressed was a lot of stuff aggregators.
Cell site location information
Remains in.
from October 26th.
I don't say they're in a store, but like, the designer streetwear store.
And that's my summary. If they disagree with that, because I was trying to prepare this for today's hearing.
I thought only one time.
Every piece of evidence.
But just to go a step further so the court understands, I agree with what the state had offered.
I can almost.
Going to what specific witnesses testify to what the inquiry was suppressed. You'd be looking at the majority of the testimony from Danny Fuller would be out. He testified to a lot of the photographs Mr. Newman's phones that predated, as Mr. Briggs said, the bookings, the YNW booking, Gmail had a game Bible sent, some game talk sent to that Gmail, all of that is out because it predates the murders. That is most of what Danny Fuller testified to. The second witness who would have testified to certain messages, maybe with Mariah Hamilton, Detective Mark Moretti testified to a substantial amount of text messages that would now be suppressed. So I believe he said close to half a day where he just read text messages off of the screen. Most of that would be out.
How about the text messages from October 26th? Were there any?
Those would remain in. As far as his phone is concerned, it was granted in part from the date of the homicide to February 13th remains in.
So state any evidence, witnesses, or testimony you want to present, or is it just your argument?
No, Judge, it's just argument. We're just relying on the trial transcript that the court has reviewed.
Your Honor, may I?
Sure.
Miss Dr. Holmes, she's not going to testify.
She's not. Okay, so
so the record is clear on this, but I'll put it in the written order also. I agree with the defense position. I'm not going to consider anything that was introduced as evidence in the prior trial that has been since subject to Judge Murphy's suppression motion. So I will only consider the things that were not, as it's been articulated to me today by the lawyer. So, defense, I'll let you give me state, let me get you the approach. You're the ones making two propositions. So, your argument as to whether the proof is evident, the presumption is great. And even if I wasn't to find that, your argument as to whether I should or should not exercise my discretion and give Mr. Dennis a bond. Go ahead.
Certainly, Judge, and that's the case law provided to the court. There's actually a presumption of correctness as to Judge Murphy's order that there was proof evident presumption great. So really what the court is considering now is just effectively has that suppressed evidence that the court is now considering changed the state's position where proof evident is no longer present. We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains. So the vast majority of the evidence that was introduced at the previous trial remains available to the state. What the state effectively lost, as I summarized, were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, with the shell casings that were recovered, the fact that the defendant's phone was traveling with the two deceased in this case along with them and then separated prior to Mr. Henry going to the hospital, the admission on Twitter that the defendant made where he said, "I did that."
So
All of that stuff that relates to the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state presented to the jury in terms of both aggravators and motive.
So before I hear the defense's argument, based on the written case, since the jury didn't find him guilty of these, that's beyond a reasonable doubt. We're able to do that in the jury. So we're now asking to find a higher standard that is proof of presumption.
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready.
free that boy Melly, man.
I have no idea what that is.
That it was a hung jury, but we don't know what the decision was.
It was, and we don't know.
Yes, we do.
It was mistried because they couldn't unanimously decide, which is the standard by which somebody is found guilty or innocent. So,
I'm not considering those. We're in this trial. Anything else?
No.
Defense, your argument as to why I couldn't find proof evident presumption grades, even if I did, your argument or anything you want to tell me about whether I should nevertheless exercise my discretion and set some form of bond or pretrial release, and if I decided to do that, what exactly are you asking me to do? Go ahead.
for the purposes of the proof evident presumption rate test, I have some factors. I know Ms. Liberty has a couple.
Free Melly, man.
Judge, I believe that the rulings by Judge Murphy that starting with the testimony of the.
They had that boy for 3 years.
Which the.
No visitation, no phone calls, man. Let that boy out,
That
man.
when she testified.
You got 3 months to the
they did not
trial.
Cross-examine her in any further proceedings. The state appealed it on a motion, on a appeal, writ of some sort, I forgot which one. And that was, and I attached it to my supplement. The fourth denied their seeking relief on that issue. So I believe that Ms. Boutros, who witnessed Mr. Moretti, the lead case agent in this case, suborned perjury, will come in with no cross-examination in the trial. And I believe the evidence of Detective Moretti suborning perjury in this case is another factor Your Honor should consider, because that didn't exist in the other trial. And it has occurred after the fact, and it's been ruled on by Judge Murphy that Ms. Boutros is going to testify unchallenged by the state. in the next trial. And I think that's something Your Honor can consider. There's transcripts of the testimony and what she saw and what Moretti did. And I think that's another factor Your Honor should consider. I believe, and there's something else that came up. You know, Judge, we got on the day of discovery cutoff, was it Friday? April 30th, so it was 6 days ago. A new set of warrants and affidavits authored by Moretti that were done a year and a half ago after Judge Murphy suppressed by this order for the same records that were stayed on appeal. And in those affidavits that he presented to various judges, mostly Judge Bober, nowhere did Moretti ever state that these issues were on appeal, that there was a stay, that they're asking for an expanded amount of records for the same social media and the same phones to a certain extent. And we found out about it a year and a half later, just the other day. We couldn't prepare defenses up until then. And Your Honor keeps reminding us we have this trial date. And all of a sudden, we get all of this other results of a search warrant that was signed by a judge who didn't even know about the appeal or what was going on with it. So all of that is additional, and we're gonna do a motion on prosecutorial bad faith, prosecutorial misconduct, police misconduct. We have to add all this stuff to it because it's new stuff that we just learned about less than a couple of days ago. But I think that's something that Your Honor should consider. What are we doing here when the 3.220 says they have an ongoing obligation for discovery? They sought this information a year and a half ago in March of 2024, however that adds up. And they've had it since, and we don't get it until 5 days ago. This is obstruction. This is absolutely unethical. This is absolutely not professional. And this is and the kind of thing that we're facing from this state attorney's office on an everyday basis. Every day. And I believe that the sub-issues there of forum shopping to go to other judges who don't have the institutional memory of this case is about, and Judge Murphy was still there back when they sought these warrants. So did they advise Judge Murphy that we're going to go do an end around? Did they advise the fourth that they're going to do an end around and seek the same and expanded amounts of information from those cell phones when the judge said it was overbroad and he suppressed all of the overbroad nature of those results of the search warrant? So it's under suppression, and they're telling another judge, go in there to try to get the same information, but broadly, so they can try to fix a warrant by not telling anybody they're doing it. So we're going to get to it at some point. But I think on a proof evident presumption grade standard, it's another thing that Your Honor should consider. At the time of the first trial, the predecessor prosecutor, Ms. Bradley, hadn't filed 3 or 4 different Brady notices for evidence that they suppressed and didn't tell us about on the first trial. And that's hearings that took place, and Judge Murphy kicked her out of the courtroom. And that's why these people are here now, because she is a possible witness, because she filed 4 different Brady notices to us. They were all different. So that's something I believe Your Honor can consider, but that happened after the trial, and it affects the credibility of the state's case against Mr. Devins. And that's a factor I would submit respectfully that Your Honor should consider. And I know I don't have them all, and I didn't mean to step on Ms. Liberty's, argument, and I know she has some other stuff.
Let me just summarize very briefly. I think the court hit the nail on the head when you said the jury couldn't reach reach a verdict and the proof evident presumption grade is a higher burden than reasonable doubt. The jury in that case did not know, it was hidden from us, that the lead detective attempted to suborn perjury, although the state knew about it prior to the trial. And that is why the lead prosecutor was removed from that case. Had the jury known that the lead detective was involved in criminal activity, I suggest that any reasonable person would totally discount his testimony completely, coupled with the fact that certain evidence was suppressed. What Mr. Benjamin was referring to was on April 30th from 3:30 to 7 o'clock at night, a little after 7 o'clock at night, we received 5 search warrants that are in my hand. They were all prepared, I believe, by Detective Moretti. They were all signed by Judge Boger. They were all signed, I believe, over a year ago that we've never received until April 30th. Nowhere in these warrants does it make reference to the fact that Judge Murphy had suppressed portions of the items that they are now seeking. Nowhere in these warrants does it indicate that there was evidence that the affiant was supporting perjury. Nowhere in the fact does it explain why the state went to a different judge, because Judge Murphy was still sitting at the time, and decided to go to a completely different judge, not disclosing any of these facts. Because I question whether or not, had Judge Boger or any judge known this, they would have taken these 5 warrants and said, go back to the original judge. And I think that is something that the court should and must ask. And it's interesting to note that on these warrants, there is in the bottom left-hand corner, despite the fact that the warrants were signed in 24, an indication that says on one particular warrant, REV-AB 1124, which I suggest must mean revised by Assistant State Attorney with the initials AB on 1124, yet they give it to us over a year and a half ago. And may I tender what I'm referring to?
Well, I didn't limit anyone in any way. I asked you 3 times, do you have any evidence you wanted to present? And you all said no, and now you're making arguments based on things that are not in evidence, and I have no idea what it is. So,
Fair enough. Do you have any objection to moving what you gave us, April 30th?
sir, you don't have to ask him.
Oh.
This is evidence you're hearing. Yes, me.
May I introduce these 5 warrants?
Are they marked? That's marked as a positive exhibit. How about that?
Yes.
I'm sorry. Okay, well, that's getting done. We'll call that defense exhibit A, positive exhibit, for purposes of the Arthur Grant.
And I move them in it.
Do you have any objection?
Yes, Judge, just because, for the purposes only of this hearing, just because we're considering the trial testimony and the evidence that was previously introduced in suppression, I wasn't going to ask the court to consider these new warrants.
Okay, well, over the state's objection, I will make them evidence for the purposes of the Arthur hearing only. So we're going to call that defense composite exhibit 1. Yes, sir. Go ahead.
The reason Mr. Benjamin and I make reference to that is because this is a continuing thing that's going on with the state. Every other day, we get something new. Concerning this case that appears was in their possession for at least a year, if not longer. And as you're looking at those, at the defendant's exhibit, composite exhibit 1, okay. I want you to know that if you look at the docket sheet, it took us 4 hours to organize the warrants because they were commingled. Warrant number 1 had pages from warrant number 2 or 3. And it literally took Mr. Benjamin's judicial assistant, like promoter, 4 hours to commingle all those pages because originally they came in so convoluted. Because I printed out how they came in as another game that the state is presenting on a case where our client is looking at the death penalty. This is no game. And they have a continuing obligation under Rule 3.22. Not to wait a year, not to wait a year and 4 months, but they have an obligation. To turn
A
it
speedy
over in a
motherfucking
reasonable
trial.
period of time. And if the warrants were signed by Judge Bober on 3/24, I think it was, of 24, what's her excuse for not turning it over to us? It's the charges that he's facing in the murder case. First-degree murder, 2 counts of first-degree murder, and accessory after the fact for the co-defendant. I mean, I don't know what the game is. I don't know what we're playing, but it's pretty disgusting, I submit.
There was one other point before I sit down. In the first trial, that wasn't surprising. It was a gentleman who took the stand, who said that Mr. Demons got out of the car and went home. It was no longer near the cell phone. That was in the first trial. That was something that the jury considered, which resulted in a hung jury. And that's something that I think is very important as we sit here today. And that's how.
I'll try not to repeat anything that, my co-counsel said, Your Honor. But in reading that transcript, I'm sure you'll get through, I bring the court's attention to the testimony again of Mark Moretti. Talking about the change of circumstances that we learned after the trial was over, after the hearing, the first hearing on the bond with Judge Murphy. We were finally advised about what had went on with Detective Mark Moretti and Christine Bradley. Why was that so important to us? Not only the fact that the jury was not made aware of that, and they probably would not have relied on his testimony, but his testimony actually impeached the testimony of Brendan Collins, the FBI agent. So when you read that testimony, you see Judge Murphy order that we redepose Brendan Collins for that simple reason. Brendan Collins had testified at that trial, which is in the CDRs, the T-Mobile, the cell phone data is in. State had put on Brendan Collins, basically to introduce his CAS reports. He had testified that Mr. Yemen's phone, or the 9807 phone, which was left in the car, but you heard testimony from Adrian Davis at that trial that phone was left in that car. He testified that you could not, with precision, give a location on that phone. He went through the different trainings he had got from the different cell phone agencies. One of the things that he had spoken about was one of the data sheets in that T-Mobile report has a column that reads environment. FBI testified you cannot rely on that they do not rely on it for the simple reason that they don't know where they come up with the algorithms that go into that column. So when you look at that column, it shows somebody could be mobile, they could be outside. Bottom line, the expert says you can't rely on it. They don't rely on it, FBI. Mark Moretti, same guy who asked an officer to lie for him, then got on the stand and impeached Brendan Collins by saying, what? That you could look at the data from T-Mobile and tell if somebody was outside, inside, or walking. He then went on the stand to give his own interpretation of what those CDR records meant. His interpretation, again, conflicted that of the FBI agent. Mark Moretti's testimony, period. We were deprived of knowing that he had previously perjured himself. We were deprived of the fact knowing that lead prosecutor had asked him and basically covered that up. And there was a change of circumstances because that was not brought to anybody's attention when Judge Murphy had made his first ruling. And for the record, that first ruling that Judge Murphy had made, it wasn't an Arthur hearing, there was no testimony put on. I believe at the time, the only testimony that was given to the court would have been over Zoom from the family's aunt or mother. Nonetheless, getting to most of my motion, Judge. There is a case out there, Norco, and what it tells us is Reeves versus Narco, 141 Southern 3rd. What it tells us is, even if the state meets its burden under Russell, and I'll get into Russell in a minute, the circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release, if the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight, is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor or GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to, one, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. So you basically have your own deputy, paid deputy, with him. Mr. Demons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demons is being accused of. It was not like, and I was looking at the different case law when we're talking about danger to the community. Those are the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms and the ankle monitor. I think we could secure that there is no threat to the harm. I think the state's biggest argument today would be to assure the integrity of the courtroom, of the judiciary. And of course, they're going to bring up the witness tampering case. That case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demon's trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion, not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not did anything. He did the right thing, Judge, and he turned himself in. I believe February 13th, 2019. 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence.
Okay.
The lawyers don't give evidence, so if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I think consider
Okay, good.
you're just saying, so go ahead.
So,
So you're just saying that, so go ahead
the
with that shit.
conditions in the jail aren't good. He's been there
Nah,
6 years,
bitch.
Judge. The Constitution says everybody gets the presumption of innocence. 6 years,
Innocent
going now
until
past 6
proven
years.
guilty.
He has substantial ties to the community, to his mom, to grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That prove evidence agree, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demmons could go at this point without being found. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we have met it. The state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected. Nothing for that.
Thank you. Steve, last word. Anything else
Yeah.
you want to say?
Yes, Judge, just responding to the points that were raised. Just so the court's aware, we have not litigated yet, but there is a pending motion to exclude the testimony of both Ms. Boutros and Ms. Bradley. It deals with a collateral matter, and we obviously believe it's not going to be relevant to trial, but they keep raising the issue, or they repeatedly raise the issue, that Detective Moretti's suborn perjury, except there's been no finding of that, and there's no evidence of that, and actually the evidence tends to be to the contrary. Judge Murphy found no Brady violation in regards to Ms. Bradley. There were no findings as Detective Moretti's testimony during the motions to suppress. And attached to the motion to exclude her testimony is the IA clearance letter for Detective Moretti, finding that he had done nothing wrong. So when they say that he's suborn perjury, there's no evidence supporting that other than their argument and the testimony of Ms. Boutros, which they say now is going to go unchallenged, except that's also not correct. While there is currently a court order saying she's not subject to cross by the state still has the ability to impeach witnesses. So she still is going to be subject to the same impeachment that she faced during the motion to suppress.
Well, that objection, I'm sorry, Judge, that's just stating a fact that's absolutely untrue.
It's not performed. Yeah, I don't know why it keeps, right?
I'm responding to their
Literally
arguments.
Out your client's family members, I'm sure she's telling me the truth, but that's not before me either. I have no idea. So, I mean, I did 10,000 bond hearings in a regular division. Family members would testify. Here's our address. Here's our finances. Here's our ability to pay. You all want to do anything? Go ahead.
Just responding, that's all. Sorry. In regards to the testimony of both Collins and Moretti, which is contained in the transcript, Brendan Collins testified as to the cell tower location information, which does put the defendant near the crime scene as well as the hospital. subsequently afterwards, as well as the following the path. What Detective Moretti testified to was the environmental data. As Ms. Liberty pointed out, the FBI will not rely upon that because they don't know how that is calculated. Does not mean nonetheless that Detective Moretti cannot testify to it because cell site location information does not require expert testimony, and he'd be subject to the same cross that he was in the first trial. I think that covers it as to the phase 1 arguments. As to phase 2, if the court is going to consider exercising discretion, obviously there's 2 factors here. One is that the defendant charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
One at a time.
He's already established that he presents a danger to the
Allegedly.
But not only
Allegedly
that,
news.
he intended to tamper
Get them,
with
get them
witnesses,
together, baby.
file in custody.
Allegedly.
It's actually the reason Mr. Henry is back in custody, because he did have a bond and that bond was revoked. Had Mr. Demons been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites that all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
Damn, man. Why he at the point that
May I respond, Judge?
shit. Yeah, respond. Say something. You got to say something.
As to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. Give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day, and another individual monitoring the property. They would be reporting back to not only the defense team, but the state attorney and to the court if there is any issue. Again,
From yesterday.
monitored.
Yesterday bond hearing.
On GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demons, while being on house arrest in a GPS tracking monitor, had abscond to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those 3 different combined statutes. It's protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
Okay. Thank you. Okay, listen, I appreciate the time, effort, and preparation on both sides. I'll get you written order as to both cases and the bond pending there. for the motion pending therein. Regarding the motion to strike notice of appearance and all of the pleadings of victims, as well as the urgent motion for order to show cause against the office of the Broward State Attorney, Harold F. Pryor and John Phillips, as well as the state's motion to remove prosecutor from witness list and for protective order. I'll ask both sides. State, I'll ask you first. How about June 4th? That's a Wednesday, June 4th.
The parties arguing those aren't going to be here, Judge. That's Joel and Stephen from our office. We're not going to be arguing those particular motions, so I'll have to consult with them. We can do June 4th for now, but
I'll set it, and if there's an issue,
Right.
deal with it.
So I can't do June.
You can't do June 4th. Okay.
I'll be gone until June 13th.
How about June 20th? That's a Friday. State, you're gonna check with your people. Defense, June 20th?
we'll check with our office after this.
Okay.
Just let the court know. I won't be here that day, but I'm not arguing those anyway, but just so the
Okay.
court's aware.
Defense, June 20th, 8:45?
Fine.
Okay, so, this will kind of, we're gonna set all three of those motions, the defense motion to strike notice of appearance and all other pleadings of victims, the urgent motion for order to show cause against the office of Broward State Attorney Harold F. Pryor and John Phillips, Esquire, and the state's motion to remove prosecutor from defense witnesses and or for protective order. All three of those I will hear on June 20th at 8:45 a.m. This defendant's trials in both of his cases will remain as already set, September the 10th at 9 o'clock. State, anything else I can do for you regarding Mr. Devens today?
Not today, Judge. I believe we have
September the 10th.
status.
So that boy go to trial September the 10th. September the 10th. He back in court on June 20th, though. Oh, shit. Let's see if they get that boy the bond, huh? Free Melly. Man, we're gonna wrap this up, man. Gotta handle some business for a minute. I'll be back in a couple hours for an R&R moment. You know what it is. That's my rest and relaxation. Well, that's where you could get you some rest and relaxation with a real nigga reaction. Right here on Home Eat TV. Hustlers on a mission every day. We in a lit house. Whatever you do, make sure you keep the light within you shining bright. You feel me? And never forget, real niggas do what they want to do. Bitch niggas do what they can. Hoe ass niggas gonna talk about it and fuck niggas gonna hate. Regardless. I promise you that. Never forget. Hey. And whatever you do, make sure you do it capital and create a positive impact today and later. Fuck them haters. Get your paper, man. My website will be back. You know what's going on. And if you don't, bitch, you will. Like, share, subscribe, post notifications, all that shit that I don't never ask for. You know what I'm saying? Hey, until next time, well, until a couple hours, you know what's going on.
Hey, I'm a hustler on a mission, grinding for that spot, a brand new pot to piss in. Trying to school my partners, I don't think they pay attention. I'm sticking to my vision, on the road to the riches. Every single day, I'm a hustler on a mission, trying to get 100 M's, nigga, I ain't kidding. I'm on a mission, 24/7, 365, until I